Good morning, everyone.
Morning.
Welcome.
Morning.
Nice to see you all. Nice to have some familiar faces on the line. Now, I'm just going to ensure we have most people on mute as they're coming in. But of course, if you'd like to say something, you can take yourself on mute because we like to keep things nice and participatory here. So feel free to ask questions or add comments into the discussion. My name is Stacey DeCulmer. Welcome to all of you. I am the Executive Director for Sector Workforce Planning and Development here at the Queensland Council of Social Service, or QCOS, as many of you would know us. And you're here because you've registered for our combined co-hosted Research Evaluation Network and Quality Collaboration Network meeting for May, which is focusing on data privacy and capturing consent from vulnerable cohorts, a really topical issue for the sector. This is a topic we have discussed a couple of times. We're really privileged to have one of our guest speakers John has joined us a couple of times beforehand. He's joined us again this year, which we're really thankful for, with the added expertise of Tonia, who is going to be talking about capturing consent and what that looks like in her organisation. So a really relevant and practical discussion ahead of us this morning. Okay, I'd like to acknowledge that I'm on the land of Yugara and Turrbal people and pay my respects to their elders past and present. I want to acknowledge their continuing connection to this space and the real value that they bring to all of us in this community here. I extend that acknowledgement to any First Nations people on the line and to the nations and the custodians of the land that you're all coming from today. And I would encourage you to acknowledge the land that you're on in the chat. So we can see the breadth of the nations that are represented across Queensland and outside of Queensland. I know that John's actually joining us from Philadelphia today. So across all the places that you're all in today. This is a bit of a snapshot of what we'll be discussing today. We've, of course, got our two guest speakers, Tonia and John. There is some time for questions. If you would like to use the chat, that's really helpful because we can try and keep some questions together or theme them. Tonia does need to go just before 10, so I'm going to do my very best to make sure that we get her out on time. So if you do have questions that we don't get to, I'm sorry for that, but Tonia will need to go on time. But if you do put your questions in the chat, that's a really useful way for us to get to them. And if there is a really particular one, we might even be able to revisit it later. Then we'll be joined by John, who's from UQ, who has joined this group previously to talk about privacy. That's his area of expertise, and you all, from my previous experiences, always have more than enough questions for John, so we will get to as many as we can today. Then we'll have a really short amount of time for some general business and talking about some upcoming events right at the end. Now, a question that we always get is, will we get slides after the session? Yes, you will. Both our guests are happy to share their slides, so we will be distributing them to the group after the session. If you look out for the post meeting email, there'll be slides and recording there, and any resources that are shared as well. Okay, so I'm going to get straight into the thing that you're all here for and I'll introduce Tonia first. Dr. Tonia De Bruin holds a senior management role in data, analytics, performance, reporting, evaluation, ethics and research. Growing up in a small central Queensland town and later moving to Brisbane for tertiary education, Tonia has first-hand experience in the service disparity between regional and metro areas. Her country roots gave her a passion for helping others and working with community. While loving her work in the fields of data analytics, reporting, performance and evaluation, Tonia is also most passionate about helping children and families who are vulnerable, including those who live in areas of socioeconomic disadvantage and or those who live with disability and domestic and family violence or experience homelessness. She's an industry advisory board member for the University of Queensland and has been a board member for Asperger Services Australia and the Morningside Panthers AFL. Oh, so a point of connection there for all of us somewhere. Tonia holds a Doctor of Philosophy, Information Systems, Master of Evaluation, Master of Health Service Management, Master of Information Technology, Postgraduate Diploma in Applied Finance and Investment, Bachelor of Business Accounting, Bachelor of Business and Management, and is a certified practicing accountant. I'm wondering what you haven't done, Tonia.
I like to learn new things, so
yeah, lots of areas of expertise there. And tell us, where in Central Queensland did you grow up?
A little country town called Ngurin. It's on Goran country and in the Boyne Valley, and the Boyne River flows through the Boyne Valley and comes out at Boyne Island, which is where the smelter is and all of those environmentally unfriendly things that Gladstone is renowned for.
Yeah.
And I went to school in Rockhampton for 5 years before moving down here to go to uni, and just never went back up. Well, I go back up regularly to visit, but you know, it's still where my heart is, and definitely you never lose that connection to country when you actually have your roots so embedded.
Yeah, fantastic. Oh, thanks so much for joining us, Tonia. I'll let yourself get sorted and share your screen. We'll be hearing from Tonia first around capturing consent, and many of you might be familiar with Yourtown and their, you know, most well-known program, Kids Helpline. But Yourtown delivers many different, a huge variety of programs. So Tonia and her team have a wide experience in how they have had to practically adapt to capturing consent from people across their lifespan, and has a lot to share. So over to you, Tonia.
Great. Thanks, Stacey. It's a real honour to be here today, and thank you for listening. I've tried to keep the presentation very general and applied, and so happy to take questions if you put them into the chat. As Stacey said, I can come back later if we can't cover them today due to my time constraints. So I just have to work out how to progress my slides with my keyboard. Okay, I also would just like to acknowledge the traditional custodians. I'm on Yagara Turrbal country today, and pay my respects to elders past and present, and acknowledge any First Nations people that we have in the audience, and look forward to your views. I'll skip that one, but just a bit of a background on Yourtown to set the context, I think, because for me, one of the things with consent is that people don't realise how broadly within an organisation it can pop up, and where perhaps we should be capturing consent when we don't, and we don't sort of necessarily think about it. So at Yourtown, we've got over 40 programs, and they cover virtual services, so KHL and the like, National Child and Family Programs, employment services and social enterprises. But we've also got corporate areas like art union and marketing and communications, evaluation, research and governance. And within all of those areas, we at some point need to capture consent from vulnerable people. It's a given that we deal with vulnerable people. We don't sort of say who is and who isn't, because almost everybody that we deal with is, by the nature of the programs that we actually undertake. We also have different engagement types within Yourtown, which result in different approaches to how we capture consent and different requirements. So we have anonymous services like Kids Helpline, where we don't necessarily know who the person on the end of the phone is or the end of the web chat, but they can choose not to be anonymous. We also have services where, so something like Kids Helpline, somebody might ring once, they might then ring again a couple of months later, or they might be getting more intensive counselling service support where they actually ring on a regular basis or contact on a regular basis and have a known relationship with a specific and preferred counsellor. So we have lots of variations in that model. So we have different programs and services which also can have different requirements because they operate with different age cohorts. So we start from naught or even pre-birth in some cases and go all the way through to 25 as our primary sort of cohort. 5 to 25 is the majority of the ages that we actually deal with, but we also have services that impact older people. So we have domestic and family violence shelters, and we have transitional houses. So we can have mothers who are over that 25-year age bracket, and we can also have children who are younger than that five-year age bracket as well through those services. We do community consultation from an advocacy perspective, but we also do community consultation through different programs that we run. So for example, over the last 2 years, I've been leading a program, like a consultancy program for Brisbane North PHN, and we've been collaborating and co-designing what a place-based initiative might look like within the Moreton Bay region specifically. And so there's very vulnerable populations throughout the Moreton Bay region, more so in certain pockets. But again, so that's another way where we have the need to capture consent. Purchases of tickets in our art union prize homes and so on. Also, with that, sometimes we take photos of children and young people, so we have the need to be capturing consent to share images either on our social medias or in our other communications. Internal staff, so we've just done a big review of KHL, looking at how we can address issues within our responsibility and response capacity might be a bit of not just responsibility. And so we've been conducted a survey with our counsellors, and so over 110 counsellors responded to that survey and provided their insights across a whole range of different topics. And we consider our own staff to be quite vulnerable due to the matters that they deal with on an ongoing basis, the hours that they work, the conditions that they work under. So they're not without their vulnerabilities. And I think that's the other thing. It's not just clients that come to us with vulnerabilities. It's those of us who deal with those matters all day, every day. It's 365 days of the year, and advocacy, which I said. So yeah, vulnerability is a given for us, not an add-on. It's just it's what we actually do. So where do we capture consent? The reality is at lots of different points. So when people come into our programs and services, there's obviously a point of collection at that stage. But there can also be specific events that occur. So one might be the transportation of children within a particular program. So the program might be about helping young parents build capability to raise their children and look after their children well. So they both might be on at a residential facility, and but there might be times when the children need to be taken somewhere, and so it's about consent for, it might be dropping them off at school or taking them to an external health event. We also have post-service evaluations. So, when people are leaving our domestic and family violence refuge, for example, we ask them to provide their thoughts on their stay and what they liked about it and what they didn't like about it. So that's another time that we actually collect that information. And then in our corporate areas as well, as I said, if we're doing particular advocacy campaigns like the Voice of Youth or something like that, some of the KHL, we're just KHL, people who have accessed KHL services are asked to provide their thoughts in terms of what those services have been like, and we use that for evaluation purposes. We also at times join with other universities and participate in their research. So our counsellors have recently participated with one of the Sydney universities in terms of the impacts on their wellbeing from the counselling services and how they respond to different situations. So so again, there's a broad range of points where we actually capture. So you can see that for consent for us, it's always there. It's in lots of different areas, and it's undertaken, the consent collection is undertaken by lots of different people throughout the organisation. So it's not a straightforward and highly structured process. So some of the current considerations, and I spoke about this, but the age and vulnerability of the clients are really underpinning everything that we do. So some of our parents are as young as 15, and so they come in looking after children. Mostly our clients are from disadvantaged and or trauma backgrounds, and we do have an overrepresentation of First Nations people in some of our contacts. So if we look at the proportions of contacts of First Nations people in Kids Helpline, for example, we've got representations through different age groups. One of the other things is we can have clients in multiple programs. So, and it's about if you consent to this program, that doesn't mean you consent in that program. And it's about understanding how that consent occurs, how we capture it. We have client autonomy can change over time. So we accept that people might make, steps forward, but they might also be impacted by things that actually take them backwards as well. And it's about how do you actually acknowledge that in your consent capturing processes. And how do we have, as children age, so they can be in multiple different programs and at different ages of their life. And so when do you update consent, and how do you make sure that the consent is still relevant to the circumstances? And I've got to say there are areas for improvement for us. I don't think we're fully across those life changes at the moment. Other things are the withdrawal of consent and how do we deal with that, and then the notion of implied consent, which comes through with a lot of our surveys and stuff like that. So, but we actually make a point of drawing out the fact that if people continue further, that they're implying consent. So for us, consent's not static, and it needs to be seen as a continuous process that needs to be or may need to be renegotiated over time due to evolving circumstances. And there's just a couple of examples there, but I know I'm short on time. So some of our challenges, obviously the power imbalance is probably our biggest challenge due to the client vulnerabilities and the service dependencies of access that come with that, and people feeling obligated to consent so that they can join a program. We capture, so when people are joining a service program, that's the point at which we actually capture consent in the first instance. So I've got some examples in the slides that show different documents that we use to actually capture consent. So there'll be an intake officer who will actually go through and capture personal information about a person, but also their consent at those points in times. We recognise that sometimes there can be a conflict of interest between what we want as an organisation and what the person themselves might want. That can influence their consent and whether they give it. An example might be if a client's got a particularly engaging story and we might think, oh, that's going to be great for public relations and putting it out in the media and making use of it, but does the client really want us to be doing that, and ensuring that if we do get consent for that process, that it's not coming with any attached conditions or pressures that the client feels. So one of the other things we're very cognizant of is the process of asking for consent can actually raise traumas from prior experiences, and that actually increases the vulnerability. So you've got that tension there of what you're actually doing is actually potentially causing harm in its own self. So the other thing is that we also recognise, particularly with say First Nations people, there's a lot of distrust with services and providing consent, and so again that's something that we are cognizant of when we're going through that consent process. And because of the complex trauma that clients can be in, they're very focused in the here and now and not necessarily the future thinking. So, and how that actually can impact. So we need to consider that in terms of how we hold that consent and what we do with it, and at what point do we review that consent and ask for changes. So the opportunities that we see is building better consent mechanisms in terms of the checkpoints within the process of consent and when we get it, and how we actually make sure that it's still valid and relevant over time. Building sector capacity and client agency to gain informed consent without inadvertently applying pressures and potentially creating prejudices. We have an ethics committee at Yourtown. It's a relatively new development, and so we are increasingly running all of our consent and related information sheets and things through the ethics committee so that they can review them to ensure that we're being appropriate in terms of what we're asking for and how we're asking for it. And that just adds a better layer of rigour to what we're actually doing. And it's been a really valuable process with the ones that we've done so far. I think one of the other things we're aiming to is being more intentional about that consent process and not just setting and forgetting at the front end, but looking at the history and the longevity of a person's experiences with us and how we actually ensure we do that. We've been doing a large digital transformation recently, and so one of the things is how do we better utilise the system to help us to manage those consent processes. We haven't nailed it yet because the system's not fully implemented, and we've still got a lot of work to do, but it really is looking at how we can actually utilise technological support to help us to better manage that process. And then the other thing we also are looking at is increasing the support that we provide to young people when they come in, so that they feel more comfortable and safe at that point that we're asking for consent. So one way that we do that is with our Indigenous youth workers and employment services. So that means that when other young Indigenous people come to us wanting to get into an employment services program, they're actually dealing with another Indigenous person, so they'll feel more comfortable and that trust can be established in a better way, and they can be more supported in actually doing that. So the other thing we're looking at doing is being more intentional about how do we actually create that agency in children and young people. So thinking about ways to empower young people so that they can make their own consent decisions at a younger age and recognise that they have those rights as they go through different age groups. And so some of those are really looking at, so if the young person isn't the one that has the capacity to provide consent at a given point, that shouldn't preclude them from the conversation around the consent process. So it's about how do we ensure that the child or young person is involved in that discussion, even though they may not be the end person that's going to be giving consent, but they're actually still an active party to it. And also the other thing that we're looking at is on our ethics committee, we're very committed to getting young people representatives on the action as committee members. So that's a process that we're going through with our youth participation area at the moment, so that they can become the champions for consent within that youth age group and ensure that it permeates all the things that we actually do through that channel. So some examples. The blurb on the left here is or on my left is the words that people hear when they ring KHL for accessing a counsellor. And if they want to at that point, they can hang up. And we do. We have a lot of people who hear this and hear that we might share their information and do other things with it, and they hang up. We also have a position statement around our duty of care and how we actually look after people. in terms of web chat, which is another mechanism for actually accessing Kids Helpline, we have content on our internet site that actually helps young people follow through. And you can see there that we've got links to the duty of care, we've got links to our privacy. So we look at providing accessible details for people to find out and access things for themselves. This is an example of when you actually drill in and go into the KHL web chat, you can see where we're asking for certain information about things. There's nothing mandatory. They don't have to provide it if they don't want to, but you can also see we've got privacy, confidentiality sort of embedded off to the side, and then we have this huge spiel, which this is one of the things I'd like to improve on, because I don't think any young person's going to actually read that, and I don't think any of them are going to. We don't give them a box at the moment to tick and say yes, we've acknowledged it. So that's a process that we think that we can continue to improve on. Very conscious of my time, so the following things are just examples from different programs. So Communities for Children, we actually hold the Community for Children funds, but we tender to other service providers who then do it. But you can see we've got like an intake form, we've got consent, and then we've got a privacy notice, and that's the person gets walked through that when they actually join. We've got, this is an example of our consent for transporting children forms, and you can see that it's got different bits and pieces, get signatures and so on. This is an example of an online survey that we use in our Kids Helpline at school, specifically targeting prep to year 3. You can see it looks very different to a lot of the others. We've got lots of images, lots of things that they can do. If you read the blurb at the beginning, you'll see that we actually talk to them at that point about consent and trying to get them to know that what happens with their data. And also the handprint there is one that actually, if they're uncomfortable and want to talk to somebody else, then we refer them to different supports that they can access and so on. This is another KHL at school one, but this is designed for the schools to use with parents if they need to, in terms of obtaining. So if the school is responsible for the consent in this case. So if the school doesn't have their own consent forms, this is an example that they can take and use with the parents. And in particular, it's about no action. So rather than asking for consent, this is designed to tell them, if you don't come back to us, this is what we're going to assume, in a way so that they're clear that they're consenting to something by not returning the form. So it's a variant on other things. This is an example of our Kids Helpline service feedback that I was talking about. You can see there we've got links to our information sheet. And again, we tell them what we're going to be doing with the data at the front. This is an example of our Easy English version of our information sheet that we use with the client survey. Again, you can see that they can contact me, but they can also contact our ethics committee if they don't want to contact me, if they've got questions, but also that we've got support options there that include other services other than us, so that they've got that independence and so on. So again, it's really about giving them options, and we've had a really good response to this change to this format. This is one that we did for an evaluation that we co-designed with Gunya Meta, who were our partners in delivering the program. And so you can see these first two are with the dealing with the school, and then the one on the right is actually at the beginning of the parent-carer feedback survey. And you can see that we've got questions there about what it is and what it's not built into that. This one's one that we've used internally. So this is interviewing our team leaders as part of the KHL review, and you can see we give them consent options and they can give their name. But again, we treat them the same as we would anybody else, with complete privacy. Nobody gets to see anything. We lock down our directory system so nobody can access the content or otherwise. And this one is publications and images for work consent. And that's it. So sorry, I know that was
No. Well,
speed dating.
I know, and you have to run, Tonia. So I'm going
Yeah.
to say thank you so much to you and let you go. And Tonia has graciously shared her email address, which is in the chat. And we will be, I know you didn't all get to read all of the slides there, but we will send those slides to you. You'll be able to look at them in detail. Thank you, Tonia. Great food for thought there. I love the idea of the ethics committee. That's, a lot of stuff there for us to mull over. Thank you very much.
Yeah, and very happy for anyone to email me directly if they want to if there's specific questions or otherwise. If there's things that you think that we're missing, please let us know, because as I said, we're on a journey, and we know we've still got a lot of room to improve, but hopefully that'll give you an understanding of the complexity that can come into capturing consent, and I'm sure John's going to to give you more insights into the complexity that comes with privacy. So enjoy your day, and I'll see you again in the future.
Thanks, you, Tonia.
Thanks, Amy. Bye.
Bye. Well, that was fast and furious, but I think that's given, Tonia has shared lots of examples there about how they're actually gaining consent from people all across the lifespan, and we will be sharing those slides. I know there's a couple of questions there, which we hope to get to, and you'll definitely get the slides of all those examples. So that will be coming to you soon. Now I'm going to hand over to John, because John's also got a lot of expertise to share with the group, and my previous experience when John speaks is that we never have enough time for all of the questions. So I'm going to introduce John. John's a professor at the University of Queensland in the law school. John is a course coordinator for the privacy law and business in a borderless world. John also teaches cybersecurity law, internet law, copyright law, and AI law. John is a former partner of a major international law firm and has 30 years of law firm experience in New York and in Australia, with a focus on technology law and intellectual property law. And currently he is a principal of a boutique law firm, Pi Legal. After graduating from UQ with a computer science and law degree, John continued to Harvard Law School as a Fulbright and Frank Knox Scholar, where he received a Master's of Law. Barack Obama was a member of his graduating class. That's an interesting fun fact, John. John passed the New York bar examination and practiced technology law as an attorney in New York State. And John has a broad range of experience, both internationally and in Australia, in applying law to various circumstances. So over to you, John. Thank you.
Thank you, Stacey. Can you see the screen now? Is that coming up?
We can see it. If you just go play, yep, that's it. Perfect.
Perfect. So thank you. I'm going to be talking about privacy today, looking at what's influencing privacy law, privacy governance, a section I'm calling the 7 sins, so common mistakes people make and what might happen in the future. And during this presentation, I'm going to be talking about consent as one of the topics. But when I'm talking about consent, it's very different. It's different to what Tonia was talking about. Tonia was talking about consent more broadly, about consenting to a service or consenting to be part of a program. When I'm talking about consent, I'm just looking at it in a narrower sense of privacy law, and that is consent to collect information about a person, consent to use that information or to disclose that information. So we just have to be, we're just a little bit narrower when we're looking at it from a privacy point of view. Of course, when Tonia was talking about this, you could see from the forms that there was privacy consents being given on those forms, but there were consents for other things. I'm just talking about privacy today. So let's have a look at the first topic. What's influencing privacy law right now? You've all seen in the newspaper the Medibank private data breach. And what's happening is there are a large number of lawsuits. So there's class actions where Medibank Private is being sued by, in effect, all the customers who are impacted, 10 million customers. There's more than one class action going on. There's complaints being heard in the OAIC, that's the Office of the Australian Information Commissioner, which is what most people call the Privacy Commissioner. So there's regulatory and legal disputes going on. We're getting lawsuits already. So here's one from just a few months ago, a decision about procedural issues in the case. Could Medibank be sued twice or only once? Could they be? And the judge said no, they can be sued more than once for what happened. We've got the Optus data breach, where there's also class actions, lawsuits against Optus for what they did. There's again more than one class action. There's been decisions just late last year where Optus tried to prevent the people who were suing them from getting access to a report that Deloitte did that looked at what caused the incident, and the court said no, that has to be handed over to the people who are suing, the customers who are impacted, and more decisions from courts. That was just one in March. We've even got law firms being impacted. HWL Ebsworth, which is a law firm, was hacked, and all their client information ended up on the dark web, including one of their clients was the federal government. And so it's not very helpful if you're in ABC News with a guy from the Defence Department with a sad face like that, talking about all his data's been hacked from the law firm that he was using rather than from his own computers. And they're being investigated by the Privacy Commissioner as well. And so you can see they're just three examples. There's hacking, customers' data is accessed or disclosed by an unrelated third party, and it ends up in investigations, government investigations, and lawsuits. That's what's been happening over the past 2 years, and that's been influencing privacy and privacy law. A few years ago, people were less concerned about privacy as an issue. It was a concern, but it wasn't a major concern. When you've got the federal government's data being put onto the dark web, when you've got 10 million customers of Medibank Private having their health data published on the dark web or sold, that starts becoming of a concern. Concern to judges, a concern to politicians, a concern to people who make privacy law. And that's had a big impact as to what we're seeing happening in privacy law. So the government was conducting a privacy review. It's been going on for a while. It's still going on. And there has been a greater emphasis on privacy, particularly because of the data breaches. The government's also brought in laws called SOCI, the SOCI Act, so Security of Critical Infrastructure. And so particularly aimed at foreign entities hacking into Australian critical infrastructure with a concern that they might turn off the electricity network or stop a bank operating or so on, and impacting hospitals as well. So certain hospitals are caught by the SOCI Act. So not every organisation is, but there's special privacy and security aspects have been brought in just recently to protect critical infrastructure. So we're seeing a lot of action in this area from the policy and from lawsuits dealing with privacy, particularly because of the cybersecurity and data breaches. So that's some background as to what's happening. What's even more scary is that we've got AI doing some of the attacks. If you're getting those annoying spam emails and texts, they're getting better and better, and they're more targeted because it's AI doing it, rather than people in Nigeria whose English is not the best doing it. You're getting AI doing it. And when you've got AI doing the attacks on your computer network, you're seeing that even Microsoft, the Microsoft legal department in Seattle was hacked. So when that's happening, you know that things are getting more serious. So let's just flip that some background to say what's been going on, what's influencing the policy, what lawyers and boards are talking about. They're talking about cybersecurity. privacy is an aspect of cybersecurity. So we'll just jump a little bit to what is privacy law, and what is privacy governance, and then we'll have a look at some examples. And so I'm going to be talking about the Privacy Act today. The Privacy Act is a federal piece of legislation. It applies throughout Australia, and it deals with privacy law. Its aim is to protect and promote privacy of individuals. So it's to protect individuals. It's not to protect businesses. It's to protect individuals. So when you're looking at it from your point of view, it's to protect consumers, customers, clients, patients. It's a data privacy law. We're looking at how is data about someone protected. It applies to the federal government. So the federal government's passed this law and it applies to themselves. And it applies to businesses with turnover of more than 3 million. So it doesn't apply to everyone. Your local hairdresser probably doesn't have a turnover of more than 3 million, so it doesn't apply to a local hairdresser or restaurant unless they've got a high turnover. And it deals with personal information. A couple of years ago when I gave a presentation to QCOS, we spoke a lot about what is personal information. I'm not going to go into that in detail today, other than to say it's information about a person. It's information about you, it's information about me, it's information about Stacey. That's all personal information. And this law has 13 privacy principles, and we'll be talking about the privacy principles as we go along. It applies to the federal government. There are some exceptions. The Privacy Act doesn't apply to ASIO, for example, so ASIO can go around spying without complying with the privacy law. Doesn't apply to state government and state government entities, but the states have their own Privacy Act. And so there's a Queensland Privacy Act that applies to the Queensland State Government. There's a New South Wales Privacy Act that applies to the New South Wales Government. It doesn't apply to small businesses, as I mentioned. It applies to personal information. It doesn't apply to data that's not personal information. So it's not dealing with, say, confidentiality of trade secrets. So the formula for Kentucky Fried Chicken's 12 secret herbs and spices is not personal information. So it's not captured by the Privacy Act. And it applies to stuff that's sort of recorded in a record. So if you're just speaking to someone and it's not recorded, or it's information in your mind, that's not captured by the Privacy Act. But most people and most businesses keep client records, patient records, and so on. And so it covers those, of course. And so some key concepts. The Privacy Act does not prohibit collection, use, and disclosure of personal information. It sets out the principles about how information should be collected, used, and disclosed. So it's not an act that says you can't do this, you can't do that. It's in effect saying, if you're going to collect information about someone, here are the principles you must follow. If you're going to disclose that information, here are the principles you must follow. And for example, so a principle says you should only collect information that's reasonably necessary, and you should only use and disclose it for the purpose for which it was collected. So that's a high level principle. You collect it only if you reasonably need it, and you only disclose it or use it for the purpose for which it was collected, unless there's consent or another exception applies, which we'll come to later on. So that's an example of a principle. It's a principled approach. It sets out the broad principles, which are called the Australian privacy principles. There's 13 privacy principles. They're quite detailed. Even though they're principles, they're the law. It's a principle-based law rather than you must do it this way. And so it's like saying, if you build a house, it must be safe and mustn't fall down, rather than saying the steel beams must be at least 6 feet, 6 inches wide, and the roof must be made of a certain material. It doesn't say that. It says here are the high-level principles. It doesn't give you the exact answers, and therefore it gives the organisations discretion as to how to implement them. Because if you were Medibank Private compared to, say, a small regional hospital, you might want to do things differently. Everyone shouldn't be doing it the same. You have to look at your circumstances. Amazingly enough, it doesn't give privacy rights to individuals. It's a Privacy Act to protect individuals, but it doesn't actually give them any rights. It doesn't give us any rights. It sets up a complaint-based procedure, but really there's no privacy rights. And in fact, there's no definition of privacy in the Privacy Act. So it's quite high level and principled on purpose. And the key question when we're looking at personal information is who should have control of that information? Should it be you? Because the information's about you. So if I've collected information about Stacey, is it Stacey who should have control of that information? Or should it be me? Because I've gone to all the trouble to collect the information. I've set up a database. It's my business. I need data. If I sell my business, I want to be able to sell the data about Stacey to the person who buys the business. So who should control this information? Should it be me, the business who's collected it, or Stacey, who the information is about? And if we look at at a broad brush, it's Stacey who the information is about, who should have it. So I'm a business, I got information about Stacey in my database because she's a customer. Stacey should have control of that, not me. I should be protecting it on behalf of Stacey, but it's Stacey's information, not my information. It's part of my business, but it's information about Stacey. And that's what the Privacy Act tries to do, give control back to the person whose information it's about. So as I said, there's 13 privacy principles. We're not going to go through them all today. If I was giving a class at university, this is about 15 hours just to go through these at an undergraduate level. And that's probably just skimming the surface. So we're not going to do that today. We're just going to look at some issues and some of the privacy, some of the principles in more detail. And so I know I've color-coded them there. They come in sort of groups. And the Privacy Commissioner has many good booklets and guidelines on the privacy principles. And so one of the principles is open and transparent management of personal information. And so this is it's principle one. And as you can see, this is a foundation principle to ensure that entities, so that's business and government, manage personal information in an open and transparent way. If I'm a business and I'm collecting information about Stacey, I should be doing it in an open and transparent way rather than in a sneaky way, so that Stacey can decide whether to do business with me or not, whether she can become my customer. And so it's an aim to be open and transparent. And organisations are required by law to take reasonable steps to have practices, procedures and systems to comply with the privacy principles and to deal with inquiries and complaints from people whose information they have. And so it's proactive implementing practices and procedures and systems to deal with privacy. It's not doing nothing, it's not complying with the Privacy Act. Proactive protection. Often it's called privacy by design, and I'll talk about that just a little bit. The idea of privacy by design is to build a safer, compliant, innovative environment. It's not to stop innovation, but it's to design privacy in it. You'll often hear about people say they'll do a privacy impact assessment. Well, that's only a small part of privacy by design. Sure, that's part of it, but just doing a privacy impact assessment is not going to get you there. Really, it's an end-to-end process. So knowing what information is collected and why it was collected, only collect what's necessary. And I'm going to come back to some of these. Protect the information that's been collected and manage how you use and disclose it. And the idea is whenever you're doing something, you should be looking at privacy at the beginning rather than leaving it to the end. You should say, we're going to have a competition to raise money or to attract more customers. Well, think about what are the privacy acts of privacy issues. Are we going to have a after-school program, and that will include driving people home? What are the privacy impacts of that? We're going to have a new database to help our marketing or to help have a patient management system or whatever it happens to be. What are the privacy impacts? You should be designing that at the beginning rather than at the end. And so privacy by design is key as a fundamental aspect of the Privacy Act. You have to think about privacy across the whole life cycle of information you've got and make sure you build privacy into it. I'm not going to go into more detail, but again, privacy by design is a big topic, but it's saying that privacy should be upfront and central, not an afterthought at the end. It's not something you say, gee, I've got to the end, what should I do about privacy? Often that's, as a lawyer, that's what I see happening. People have said, I'm just about to implement this new system or this new program or this new marketing campaign. Are there privacy issues? And you look at it and say, well, the whole thing might not work because you haven't thought about privacy early on. So it's to think about privacy up. So let's have a look at the 7 sins. That's sort of an introduction to privacy and privacy governance. But what we're seeing, what the government is saying, what the Australian Institute of Company Directors is saying, what privacy experts are saying is privacy should be central to everything you're doing. So the 7 sins, these are things that I often see people doing wrong. And so I'll go through some of them more quickly than others. So sin number 1, not having an up-to-date, complete and comprehensible privacy policy. Most organizations have a privacy policy, but they might not be easy to understand. We even heard Tonia say, oh, she was looking at one of her privacy, it was a privacy consent, not a privacy policy. And she looked at that and said, maybe the people who, and I think it was young adults who were meant to be looking at it, she said, they probably don't understand it even if they read it. So the idea is to have it complete, comprehensible, and up to date so that the people who are your typical customers, patients, clients can understand it. It has to be comprehensive. And when we're looking at it, so this is what's on the screen now is what the law says. It needs to be clearly expressed and up to date, easy to understand, easy to navigate, only include relevant stuff, suitable for publication on the internet and reviewed regularly. And it says it's a policy about how an organization manages personal information. It must include a whole bunch of things in it. This is what the law says. I'm not making this up. It has to have what information's collected, how you collect it, why you collect it, how you hold it, how you use the information, how a person might be able to access the information, find out what you've collected about them and correct stuff that's wrong, how to make a complaint, and is any information transferred outside Australia. They're all the things that need to be in the privacy policy. I've looked at many privacy policies and done reviews of them. Many of them are deficient. For example, they don't cover all the data that's collected or used. And if you look at an organization, organizations collect data about potential customers, existing customers. You might get an inquiry from a family member of a customer, so you're collecting information about that family member, people applying for a job, people who are working in the organization, suppliers. So you're collecting information about who your suppliers are and who works for your suppliers, who your contact person at the supplier is, people who attend your office, people who attend seminars. There's a whole bunch of information you collect. If you've got CCTV cameras in your premises, that's all data you're collecting about people. Often I read the privacy policy and it only talks about people who visit the website, and it forgets all the other information that the organization must collect. It's often a huge amount of information about people collected from various sources for different people in different roles. So often they only focus on the website rather than the business as a whole. I've read privacy policies and I don't understand what they're saying, and I'm a lawyer who's been doing this for 30 years. If I can't understand it, I can't imagine how the average customer would understand it. And I've seen privacy policies that haven't been updated for years. They're not even applying the right law, let alone explaining what they're doing. And so by not having a privacy policy, and the privacy policy must be published typically on your website, if a privacy commissioner looks at it, can easily say this organisation clearly hasn't done a good job even on their own privacy policy, so how could they have good privacy practices? So sin number 2, not having a senior person who's got a comprehensive view of privacy in the organisation. Privacy is a central legal topic now for the whole organisation. Often I'll see a marketing person or an IT person who's delegated to be the privacy person as something they do in their spare time. They're not senior enough in the organisation. They're only looking, if they're an IT person, they're only looking at privacy in relation to IT systems. If they're a marketing person, they might only be looking at privacy in relation to marketing. It has to cover the whole organisation, everything they do, and the person should have a seat at the table for key decisions that organisations make. And so it's more than just a privacy officer. A privacy officer is part of it, but it's becoming someone who's might not be a direct report to the CEO, but a direct report to someone who reports to the CEO. It's becoming a very important role to make sure that these issues are done. One of the hardest things about privacy and cybersecurity is it often falls across many areas: marketing, IT, accounting, customer service. And so it's not just one aspect, it falls across the whole lot. And some organizations, something that falls across the whole lot falls nowhere rather than falling in a senior position. So it's important having someone who does that in an organization. Sin number 3, collecting unnecessary information. The law says an organization can only collect information that's reasonably necessary for their work. A federal government agency can only collect information that's directly related to their work. You can't collect information on the basis that it might be necessary in the future. It's only stuff that's reasonably necessary now. I'll give you an example of something. When I went in to a hospital during COVID to get a COVID vaccination, it was being done in the medical clinic of the hospital. They had an intake form, and the intake form asked me for my next of kin. It asked me my religion, and it asked me what I wanted to do if I died in the hospital, about maybe it was about last rites or something. Clearly that was the intake form for someone going in for an operation, not going in for a COVID vaccination. You don't need to know someone's religion or next of kin to do a COVID vaccination. The form wasn't appropriate. They were collecting information that they didn't need, and that was a breach of the Privacy Act. In most circumstances, collecting on the basis that it could be necessary is not, in the future, is not sufficient. You can't collect information that you don't need. So it could be just irrelevant or no purpose. And so the Privacy Commissioner has come out and said, this is not reasonably necessary. You shouldn't be collecting information, more information than is required for the function or activity. And so many forms I see, they've got information just because it's always been on the form. You shouldn't be collecting it. You can't collect it in case it might be needed in the future. You can't collect information about a group of people when you really only need it about some of them. And you can't collect it to help a related corporation if it's not necessary to your activities. And so, and one of the reasons this is an important thing, and there's a lot of emphasis on this now, is that if there's a data breach, the more information that you have, the more consequences of a data breach. So if you don't need it, you shouldn't collect it. So if there is a data breach, it's not breached. Only collect what you need. So sin number 4, keeping information longer than you needed. This is the flip side of what we were just talking about. You should delete. The law requires you to delete or de-identify information if it's no longer needed. If there's no requirement or justification for retaining the information, you've got to delete it or de-identify it. So that's what the law says. When there was a data breach of a HR system a few years ago. One of the banks had 20 years of resumes in that system. People who applied for jobs 20 years ago, they'd never deleted it. They thought, oh, we'll just keep it because it might be necessary in the future if that person applies again. Well, if someone applies for a job 20 years later, their resume from 20 years ago is not going to be relevant at all. But there was a data breach in relation to that HR system. And so a huge number of people's data was breached, more than should have been there. So if it's no longer needed, throw it out, delete it. And there's a big emphasis on this. Sin number 5, misunderstanding consent. And so this is going back to what Tonia was saying before. Many people misunderstand consent when consent is needed to collect information or to use information. It is one of the hardest areas of privacy law. And so the fact that people misunderstand this is not a surprise. It is a difficult area of law. There's 2 key aspects. We're looking at consent for collection. When can I collect information about Stacey? And consent for use or disclosure. When can I use the information I've collected and when can I disclose that to someone else? The Privacy Act treats use and disclosure together. They're similar concepts. So collection for consent and collection for use and disclosure. So if we're looking at collection, believe it or not, you don't need consent to collect information about a person if it's reasonably necessary for your business. You only need consent if the information is what's called sensitive information. And I'll come back to that. So if Stacey was my customer and I asked Stacey, would you prefer, let's assume I'm a hospital, would you prefer a single room or a double room? I don't need consent. Now, of course, if Stacey's telling it to me, she's most likely implied consent, but you don't need consent to collect that information. But if I'm asking Stacey about her medical history, then I need consent from Stacey to collect that. And it's obviously if I'm asking you, and you can see that I'm writing down on a chart as I'm asking you these questions, there's an implied consent there, but you need consent. So consent is not generally required for collection of personal information, but it is required if it's sensitive information. And so there's a big distinction between it. So if you've flown on some airlines recently, you'll hear that the message at the beginning about the privacy, when you go on hold and they play these messages about privacy policy, they've changed those recently because if you order a special meal, you can order a meal that's, say, a Hindu meal or a special diet meal. Well, that's sensitive information. Your religion or your health, like diet is a health-related issue, they need specific consent to do that. They don't need consent to work out if you want an aisle seat or a window seat, but they do need consent if they're collecting information about your religion or your diet. And so looking at information, it's important to work out, are you collecting sensitive information, because you need consent to that. And we've already said an organisation should only connect what's necessary, and an organisation has to tell you what information it collects about you, which I'll come back to in a second. And so I said sensitive information is a special case. Here's a list of things that are regarded as sensitive information, including health information is sensitive information. Sexual orientation and practices is sensitive information. If you're collecting that, you need consent. So you can't write down observations about an individual's health or about their ethnic origin without their consent. You may only collect sensitive information where it's reasonably necessary and the individual consents to the collection. And I said it could be implied consent, but it's needed. And consent, there are under the privacy law, there is 4 key elements. It has to be, the individual has to be informed before giving consent. They have to know what they're consenting to. It has to be voluntary. current and specific. You can't rely on necessarily. You can't rely upon a consent that was given 5 years ago, and the individual has to have capacity to give consent. And so, you know, if an individual is drunk, for example, they can't consent. And consent is typically obtained at the point of collection. It doesn't really work to get consent after you've collected it. It's at the time or before collection, and it could be express or implied. So very difficult area. And so, but in summary, the question is the person consenting, and what are they consenting to? And if you give someone a long, complicated form that they wouldn't understand, it's probably not valid consent, because it's not informed consent, because the form might be way too long. So it has to be something which is understandable. Then we've got consent in relation to use or disclosure. You can only use or disclose information you hold for the purpose for which it was collected, unless an exception applies. So if I'm an online store and I'm collecting your name and address so that I can mail you the parcel, well, I don't need your consent to use it to mail you the parcel, because I'm collecting it so that I can mail you the parcel. If I'm collecting information about you to give you medical advice, then I don't need your consent to give you medical advice, because that's the purpose I collected it. It's only if I'm using it for a different purpose than what you reasonably expected me to do with it, do we have to be concerned. So you can collect information if it's reasonably necessary and use it for the purpose for which it was collected without consent, unless it's medical advice, unless it's sensitive information. And so consent is, in many cases, not actually required to collect or to use or to disclose. It's only if you're collecting sensitive information, health information, or using it for a different purpose. So if I'm collecting information about you to give you counselling, and then I want to use that information to sell to a mailing list so that you could get, I can sell you mailing lists so that you could be sold different products or services, well, that you need consent to do that. And so this is the way it's explained in the law. It's a little bit complicated. It says, if you hold information about an individual that was collected for a particular purpose, then you must not use it or disclose it for another purpose unless you've got consent or unless an exception applies. We'll have a look at the exceptions as we're going along. So if you're wanting to use it for a different purpose than for which it was collected, consent is needed. And there are exceptions, and there's many exceptions in the Act. So sometimes if you'd reasonably expect it to be used for a different purpose. So for example, if I sent you an invoice for my services and you didn't pay, you'd reasonably expect that I'm going to give your information to a debt collector to try to collect the debt. That wouldn't be a surprise, and so you could do that. You don't need to get consent to go to a debt collector, because no one would ever give consent. And so if it was the person reasonably expected you to do that. An example that I've used is if you're going to a doctor and you've referred to a specialist, the person would reasonably expect you to send their medical records to the specialist. You don't have to get specific consent to do that. There are permitted health situations, which we'll come to in a moment. You don't need consent in those permitted situations. So some of it, and we'll have a look at those permitted situations in a later slide. Sin number 6, not providing a collection notice. This is a very simple but often often not complied with. And so what the law says is, when you collect information, you need to take reasonable steps to tell the person who you collect information from all of these things, these points 1 to 8. How many times have you actually been given a collection statement when information's been collected about you? Very rarely. But the law requires that when information's being collected about you, the organisation doing the collection must tell you these things. Just giving you the privacy policy is not enough. Privacy policy talks about the organisation's privacy collection practices. This says, I'm collecting your name and address and your blood type for the following purposes. This is who I am, and this is how you can get in contact with me. And so having a collection statement and a privacy statement is also, you need both of them, and the collection statement should be designed at the particular information that's collected. Sin number 7 is being too strict, not rely upon the statutory exceptions. The law has a huge number of exceptions in it to everything I've just said, because things would not work if it was strict. For example, if I'm having a heart attack and I'm lying in the street, I'm not going to be able to give you consent to certain things. And it would be ridiculous if the law said, well, we'll just let the person die because privacy restrictions. Another example is if you're in the doctor's office and the doctor starts asking about family history. Has your father had a heart attack? Has your mother had cancer? How are your brothers and sisters' health? The law says that can be collected. It would be ridiculous if the doctor then had to go and call up your mother and your father and all your brothers and sisters and ask for their consent to collect this information to do a family history. The law says that's not necessary. So there's exception upon exceptions. Some of them are broad, some of them are narrow. Most people forget about them and they go through all this pain of trying to get consent when consent is not needed because an exception applies. And so, for collection, for example, and I mentioned this in a prior slide, if you're going to collect sensitive information, the individual can consent, or you could rely upon one of these exceptions. So some of them are not going to apply, like an enforcement body. The police don't need to get consent, for example, in certain circumstances, or if there's a subpoena or a search warrant, then you don't need consent. But there's things called general situations, health situations, and non-profit organisations have special exceptions. Now, they're much more detailed than appearing on the screen. It takes up pages and pages to explain what each of them are, so I'm not going to go through all of them. And so what the Privacy Commissioner says, for example, an organisation must usually ask for your consent to collect sensitive information. There are situations where they don't need to. For example, if you're in urgent need of medical treatment and you're unable to consent because you're unconscious, right? So this is from the Privacy Commissioner giving this as an example where you don't need to get consent. And so there's a whole list of them to lessen or prevent a serious threat to life, health or safety, locating a person who's reported as missing, defending a lawsuit, and so on. So there's a whole bunch of things where you don't need consent. Consent, providing a health service, provided the person who's providing a health service is regulated by a code of conduct that deals with privacy and confidentiality. So if you're going to a GP, then the GP is providing a health service and is a member of the Society of GPs, which have got obligations of confidentiality and privacy on your members, then you don't need the consent. There's a whole lot more where you don't need consent to collect health information, or when there's or to collect other sensitive information, or to use it as well. And I'm not going to go through all of those situations now because that would take a long time, and it would also be misleading because by providing a health service, that little summary there is not totally accurate because there's conditions and so on that apply to that. But really, what this is saying, privacy law is much more complicated than many people think. Consent sounds like an easy concept, but it's not. In many circumstances, it's not needed. And even where it is needed, there's exceptions that you might be able to rely upon. And so it does get complicated. And time and again, I see people saying, oh, I can't do that because of privacy law. often they can do that. They just don't realise that privacy law's got consent to help them through. And health-related issues are ones that where the Privacy Act has got lots of exceptions. Another example is if a person doesn't have capacity, you're dealing with someone who is, due to a medical or other reason, is unable to make decisions themselves. Well, they can't give consent. And so that the Privacy Act delegates that to a caregiver or a responsible person to give consent on their behalf. Again, otherwise you'd never be able to get consent. So what's next? There's a bigger focus on privacy at the moment, particularly because of cybersecurity. There are more investigations by the Privacy Commissioner. There are larger fines, more lawsuits by people who are impacted. There's less tolerance where there's no or little compliance, and the health sector is a high focus. The health sector is a high target for cyber criminals. It's a high focus for the Privacy Commissioner. And when you look, I look at all the statistics as to things that have gone wrong. Sometimes it's people are doing, have got complicated databases and don't have the right security. But sometimes it's as simple as emailing things to the wrong person. So there's about 250 major privacy breaches each year where an organisation has mailed spreadsheets or customer lists to the wrong person. So just simple things. Don't CC all your customers or email the spreadsheet by accident. That happens more than you'd expect. So now time for questions, Stacey. I haven't been reading the chat as we're going along, so I think we've got time for some questions.
Yeah, thank you very much, John. So much information there, and there are a couple of questions here in the chat. Your last comments there about the wrong emails going to people remind me now our local Facebook group. Someone posted just the other week that someone had been given the wrong discharge papers when they went home from the hospital. They got home and they looked at their discharge papers and it was someone else's. So those kinds of things can happen all the time, can't they? So presumably their discharge papers are off with someone else. Yes.
And there have been some cases where someone's gone in for an AIDS test and they've emailed the results to the wrong person. Which can be quite devastating to the people involved.
So we've got a question here, and a couple of people have liked it, which usually means a few people are thinking the same thing. What are some examples of implied consent?
Yeah. Often, if you're just asking someone information, and so you're a caregiver and you're asking someone, how did you feel last night? Are you feeling safe? And so on, and the person is telling you, and they can see that you're taking notes, then there's implied consent to the collection. Because if a person didn't give you that information, if they said, oh no, I don't want to tell you that, well, then there's no consent. Or if they say, look, I'd like to tell you this, but please keep it anonymous, or please don't write it down, I don't want this appearing in your records, then there's no consent. But if they don't say anything, you would usually be an example of implied consent. So that's the most common one. Someone just giving you information directly, because there's no obligation to give information. If I ask you, Stacey, what did you have for breakfast today? And you tell everyone, well, there's an implied consent that we could use that in our notes.
And in the context of the service delivery in the community services sector, that implied consent, we would need to consider that person's capacity to give consent. So, for example, a young person or a child might not have any idea what case notes are and what happens to case notes.
Yeah, correct. And it has to be done in a fair and reasonable way. And so that often looks at, is the person understanding what's going on? So if it was a child, or if it's one of the examples that the Privacy Commissioner uses is, you've just woken up from an operation, you're under the effects of anaesthetic, and someone comes in and asks you a whole bunch of questions and you give consent at that stage. You have no memory of even what you were saying, or a child might not. And if someone is asking you a question, do you want peas or beans for dinner? That's a big difference to, would you like your appendix removed this afternoon, right? So there's a different level depending upon the seriousness of what you're doing.
Absolutely. Gillian's asked, do the rules regarding consent around secondary purposes apply where information is de-identified? For example, provision of aggregate client data, including sensitive information for systemic advocacy purposes. That's a really good question. Thanks, Gillian.
That's a great question. So first, once you de-identify the data, it's no longer personal information. So none of these rules apply. So to say, 6 people, we've got 10 people in our database, and 6 of them like this and 6 of them don't like that, and you don't know who they are, then it's not personal information. It's about a group. So if we said, an example, you see the newspapers say, 55% of the people in Brisbane are going to vote against the Premier, right? So we don't know who they are. It's just a general de-identified. The trouble is, often it's not properly de-identified, and so could it be reverse engineered? And so, for example, if you did a survey and you said the people living in Roma who are in wheelchairs like X, and everyone knows there's only 2 people in Roma in wheelchairs, and that's not de-identified. An example, in the law firm I used to work for, they did a survey and they said all female tax lawyers like this. Well, there was only 1 female tax lawyer in Brisbane. So you can't say, the Premier of Queensland is X. Well, everyone knows it's only 1 person. So it's not de-identified.
Yeah. So that's the consideration in regional law. Yes, if we're working with cohorts where there isn't a large group, Yeah,
so if it's small samples. And CSIRO, in fact, the Australian government, one of the health services commissions who collect information about Medicare claims, they wanted to release a big database so that for research purposes, a very, very good purpose. They spent a lot of time trying to de-identify it, and CSIRO did a study and said, look, in theory, we can re-identify 100 of these people out of a large database. And they said, look, and they got in serious trouble for that, even though no one actually did re-identify them. So you have to be extremely careful that data can be re-identified in small samples or in certain cases.
Yeah, really, that was a great question. Thanks, Julian, and great clarification. Thank you, John.
And so just to give it another comment, Gillian, often people will say, because things could be re-identified, we're going to still treat it as if it's personal information, even though we've tried to de-identify it, because it could still be, and so therefore get a consent. And so often people will say, and there are lots of exceptions like implied consent and all the other ones, people will say, I don't want to rely upon that, it's not clear, let's just get consent where we can. And they will, and so some organisations take the view we will only act if we have express consent to all of these things, because then we don't have to worry about the issue. Now, you shouldn't say I'm going to leave someone dying on the side of a road because you couldn't have express consent, but in certain circumstances that's a sensible thing to do, because this area gets difficult.
Chris has asked here, is it necessary for a wet signature?
No, not necessary. So, but
for anyone on the line wondering, what is a wet signature?
It's a pen and ink, basically. So, the old days of putting a feather in an ink pot and it was wet and you had to put a blotter on it. So the idea is, it's wet signature means using a pen, I think. So electronic signatures, I could just send you, signature's not even required. So if you said, Stacey, you sent me an email and say, do you want me, do you consent to me selling your information to Yourtown? I could write back and say, yes, I consent, or that's okay. That's sufficient.
Yeah.
So So it's even oral consent is sufficient, but it's hard to prove that you got the oral consent, right? So
yeah, of course. Yeah.
So.
Excellent. Any last questions for John? I'm actually very impressed that you got through all of that content in the time that you did, John. You're obviously well practiced.
It's the same questions come up over and over again. The same issues arise.
Yeah.
It's easy to talk about it at a high level, but when you actually start to apply it on particular cases, this is a very difficult area.
Yeah. Yes. And John's slides will be sent to all of you, so you will be able to have a look at in greater detail at some of the examples and some of the comments that John had there. There's lots of comments here. I don't know if you can see them now, John, in the chat saying how helpful and useful that was. So thank you very much for your time. Enjoy the rest of your time in the States.
Yeah, so it's
things that you're doing.
Yes, it's Wednesday night here in Philadelphia. I'm visiting my daughter, who's a social worker here in Philadelphia, and she's been spending the last hour and a half trying to keep their Australian Shepherd dog under control. So she's done a marvelous job.
Oh, well, you can tell her she can let him loose. Okay. Thanks very much, John. Really appreciate it. Thank you.
Bye-bye.
Bye. Oh, well, that was a lot to think about there. And yeah, as we said, we'll be sharing those slides. Now we only have a couple of minutes left. I'm going to race through just some of the updates we wanted to give you. Now, if this is your first time attending one of these meetings, as I mentioned right at the beginning, this is a co-hosted meeting between the Research Evaluation Network and the Quality Collaboration Network. If you're interested in the Research Evaluation Network and you aren't familiar with that group, the email address is on your screen now, and some information more specifically about that particular network. It's for any social service staff in the research and evaluation roles. You're encouraged to attend, and the network has a strengths-based participatory focus that leverages and draws on the values of current knowledge, expertise and capabilities that exist within the sector. And that network invites lots of different people from across the sector. For example, Tonia from Yourtown, to share their expertise with the group, and they explore lots of really fantastic and relevant topics. And many of those topics are ones that the Quality Collaboration Network also identify as topical for them. And the Quality Collaboration Network is a group of peers from across the community services sector. It's been around for many, many years. They're really a productive group who have a focus on collaborative practice, peer support. The main thread running through the organisations that are involved with the Quality Collaboration Network is most of them are complying with the Human Services Quality Framework. So that's often the topic that we come around together around. We share lots of quality and compliance focused information, lots of resources, particularly if you're a small organisation that doesn't have a team or a person who has a role dedicated to quality compliance. This is a really useful group to draw on. In my experience of chairing the Quality Collaboration Network for about 6 years now, they are really generous with their knowledge. So please come along to that network. Both the Research Evaluation Network and the Quality Collaboration Network advertise their meetings on the QCOS website on the events tab. And we've got some coming up very soon that I'll share with you. We also have a dedicated email address that's there on your screen. Okay, we also, as part of those networks, both of those networks have a Teams forum. So if you use Teams, you're welcome to apply to join the Teams. And I believe the link there to join the Teams is there in the chat. We also have YouTube playlist with recordings such as today's meeting and other sessions recorded on the YouTube playlist if you'd like to catch up on some of the previously covered topics, and a research and evaluation resources hub on Community Door. And if you're not familiar with Community Door, there's a whole heap of things there for you to discover. It's a bit of a treasure trove of resources for this sector, including things like case note writing guides, human rights resource library, all kinds of things on there. So what have we got coming up? The next one is on the 23rd of May. the Research and Evaluation Network. They're looking at evaluation excellence in the community controlled sector. The link to register is on the events page and in your chat. Please come along to that to hear more about what some community controlled organisations are doing in their evaluation of programs. And in July, the Quality Collaboration Network is going to be meeting to discuss data governance and benchmarking. We will have a guest speaker we haven't had before. Gabby is Food Agility's data policy manager, and she's going to be speaking to us about what benchmarking looks like applied in different sectors. That's it, right on 11. I just got there in time. That's me on the left. Kelly is in the middle. We both have a focus on the Human Services Quality Framework and quality compliance at QCOS, and the lovely Amy is there on the right, who runs the Research and Evaluation Network. Please get in touch with us if you would like to chat, if you'd like to know more about the networks, or if you have ideas about topics, or if you just want some organisational support. And we would love to see you next time. Please let us know how you found today. I know it's always a bit fast and furious when we have multiple guest speakers, so we'll be sending out that post-meeting email and with all of the content covered today, so you can have a bit more time to digest it. Thanks for your time, everyone, and enjoy the rest of your day. Thank you. Thanks very much.
Great sharing, Stacey.
Oh, just got there.
So on time.
There's always a bit of an adrenaline there at the end if you know you're about to run over. And poor Tonia, I could see that she was trying so hard to get to the end of hers.
Oh, the last 5 minutes. Yeah, she held on as long as she could.
She really did.
So
after our meeting with her, I thought there's no way she's going to get through what she plans to in 20 minutes. Not a chance.
I wondered that too. Oh well.
So much content.
We've
got 21 poll results. So
oh,
that's
excellent. That's really good.
Cool.
Brilliant. Thanks, Kelly. Thanks, Amy,
Okay.
too.
Thanks,
See you,
Stacey.
folks.
Thanks, Kelly. Thanks, Michael.
Thanks, Michael.